Hello, my name is Killian Garvey. I'm a barrister at King's Chambers, and I'm going to talk to you very briefly about a recent appeal decision I was involved in that deals with the questions of conditions precedent and whether a condition goes to the heart of the planning permission. Whilst I'm talking to you about this, you can distract yourself by trying to guess what that is a painting of. I'll give you a hint. It's two things at once, but my girlfriend recently painted me that, so you can tell me what you think it is. So the appeal decision I was involved in, the issue, it was a lawful development certificate appeal. The appellant, who I acted for, he had secured planning permission from the Peak District National Park Authority for a local needs dwelling, and that was granted in 2008. And the permission was subject to two pre-commencement conditions, one of which related to contamination. The permission also, and this is important, had a Section 106 agreement associated with it, which restricted the future occupancy of the dwelling to local needs. And the appellant came to the appeal team and was trying to remove this local occupancy condition. And the question that arose was, well, has this permission ever been implemented? Because what the appellant did is he didn't discharge any of the conditions, and he constructed the dwelling. So he thought he was building out the permission, but actually, in failing to discharge any of the conditions, the question that we had to ask ourselves is, well, has he actually implemented the permission if he hasn't discharged the pre-commencement conditions? And one of the conditions, the contamination condition, it was classically worded in terms of, prior to the commencement of development, you've got to submit a contamination report, and that's got to be submitted to the local planning authority, and it's got to be approved. So it does satisfy the criterion of it being a condition precedent in terms of the language. But the second question is, well, does it go to the heart of the permission? The local planning authority said it didn't. They said that the dwelling that had been constructed on site was the 2008 permission. We said otherwise. We said no, this contamination condition does go to the heart of the permission, and the fact that it hasn't been discharged means that what the appellant had built out was not in accordance with the permission. However, because it was built more than 4 years ago, it was immune from enforcement as an unrestricted, development. And we went to appeal on that point, and it went to an inquiry, and happily the inspector agreed with the appeal team, agreed with the submissions we made, which the inspector effectively said, acknowledged that during cross-examination, the council's planning witness accepted that they weren't an expert in respect to issues relating to contamination, and ultimately the local authority who thought, the relevant expert who did think it needed to be a pre-commencement condition, had given that advice in 2008, and the planning witness deferred to that evidence. And helpfully, the inspector said, well, whether something goes to the heart of the permission, the subject matter of the condition need not be central, and it not concern itself directly with the activity permitted, for example, the extraction or the building. So the inspector said, well, whilst in this case contamination issue cited in the condition may not itself have related to the actual conversion works, it is manifestly about the essential subject matter of the planning permission, which the authority agree relates to the occupation of the land for human habitation. So ultimately, if it's the planning permission, if it's for a dwelling, obviously it needs to be safe for humans to live there. So a contamination condition, making sure it is safe, does go to the heart of the permission. And on that basis, the inspector said, well, it follows that it does go to the heart of the planning permission, and therefore the failure to discharge the condition means that the permission was never implemented, and consequently the development was immune from enforcement. In this instance, the failure to discharge conditions was actually helpful to the appellant and something that we relied on. But that's, of course, because he was immune from enforcement. And the fact that we've never implemented the permission means that the Section 106 agreement doesn't bite. So it no longer has that local occupancy restriction. But of course, there are numerous examples where the failure to discharge a condition will mean that you haven't implemented a permission, and therefore you might not be immune from enforcement and you might be subject to enforcement action. So it underscores the importance of actually discharging those conditions. The appeal reference was 3252910, and it was the scheme was called the Garrett, and I was instructed by Emery Planning. Thank you.